Hi, welcome back. Here we are in week 3. This lecture is going to continue our discussion on legal principles in tort law. This week, though, we'll be dealing with reckless misconduct and those intentional torts. Last week, recall, we addressed unintentional torts. In a minute, we'll be looking through those intentional torts that include assault, battery, defamation, invasion of privacy, and infliction of emotional distress. We'll address the components that make up those intentional torts, as well as possible defenses to those intentional torts. We'll also be addressing reckless misconduct as well. I want to briefly return us to this slide that we saw in last week's lecture as well. This gives us our overview of torts. Please recall we dealt last week with negligence. It's a very important concept you see in the world of sport and in the sport management discipline. This week, though, we'll move on and address that reckless misconduct, and then obviously intentional torts. And falling under intentional torts are those 5 areas that we will be addressing. I think this is a great visual. It gives us a visual representation, particularly for visual learners, to help us recall this breakdown and keep torts clear on intentional, unintentional, and reckless misconduct. Let's recall degree of intent. Intent is the ever important concept when we're addressing torts. Last week we talked about those unintentional torts or negligence. In those instances, individuals had no intent to act and no intent to harm. Therefore, they were negligent. When we begin to talk about our concepts for this week, we learn there is intent involved. For reckless misconduct, then, there is intent to act or behave in a certain manner, but there is indeed no intent to harm someone. Therefore, it's reckless. Intentional torts, though, move towards both intent to act and intent to harm. Therefore, the individual doing the intentional tort indeed has intent to act and behave in a certain way, as well as in addition to harm someone else. Again, please recall this notion of degree of intent will help us with our classification of unintentional torts and or negligence, reckless misconduct, and intentional torts. You'll notice throughout the remainder of this session, intent will again be the key concept, in determining where we are going to classify these torts. First, our first area we're going to address is reckless misconduct. Along our continuum, this falls in between unintentional torts or negligence and intentional torts. We'll see where we begin to move along that continuum of the individual now has an intent to act, but there's not necessarily an intent to harm. I've provided a definition here that I think is helpful. It's defined as an action that is willful, wanton, or reckless. There's no intent to harm, but the degree of care exercised is so far below the usual standard that in effect, it's treated as an intentional act. Okay, as we learned in our previous lecture, individuals found guilty of reckless misconduct might be liable for punitive and compensatory damages. Please recall what those are. Punitive damages are to punish the defendant for the behavior. Compensatory damages are to compensate the plaintiff for loss. Those damages might include loss of work, medical bills, loss of or emotional distress. Okay, the reckless misconduct actually is a fairly common issue when we think about participant sport. And you'll actually see some reckless misconduct cases when you address your case briefs. Let me give you an example. Let's say, for example, at practice, Sarah is practicing her volleyball serve. In an attempt to practice her accuracy, she decides to serve at her teammates who are stretching at the far court. In doing this, one of her serves accidentally hits Nora in the nose and breaks it. Please note, in this instance, Sarah had an intent to act, although she had no intent to harm. Therefore, this behavior could indeed be classified as reckless misconduct. We could see how this could regularly happen in participant sport. Notice, again, no intent to harm, but there is an intent to act, and that act or those actions are willful, wanton, and or reckless. We're going to move on now and talk about intentional torts. As we've already reiterated, there is indeed an intent to act and an intent to harm. I want to call your attention to the language of that, an intent to act and an intent to harm. I haven't talked about this yet, but it's important to note that the defendant doesn't actually have to cause harm. There only has to be an intent to harm. Therefore, the plaintiff indeed can have a case of an intentional tort if there's belief that there was an intent to act, an intent to harm, and that could be enough to constitute damages. We have to keep that in mind in our coming discussion of intentional torts. The first intentional tort we will be addressing is assault. Please recall back from our diagram slide on slide 2 that we'll be addressing 5 intentional torts. In order for assault to be present, we have to have the following 3 elements to constitute a civil assault. Those 3 elements include, I've listed them here. Let me paraphrase. The first condition is that the defendant intended to cause harm. Second is that the plaintiff felt reasonable apprehension of the harm. And third, there had to be a lack of consent and or cause for the harm. It's important to note in assault that touching does not actually have to take place. This is going to be our key distinction between assault and battery. The line between physical assault and contact and mere apprehension marks that line between assault and battery. Please note in assault, contact or physical touch does not have to happen. There only has to be those previous 3 elements we talked about: an act, an intent, and cause. Therefore, the plaintiff must be aware of the possibility of contact, not that necessarily contact occurred. Let's talk about an example that we might indeed see in the world of sport. While this example might be somewhat silly, it helps us classify and understand the notion of assault. Let's say, for example, we have a baseball pitcher and a batter. Freddie is our pitcher. He threw a pitch that unintentionally got away from him and passed dangerously close to Harry's head. Harry took offense to this closeness and charged the mound, and in doing so also threw his bat at Freddie. But in throwing his bat at Freddie, he missed. He didn't touch Freddie. In this instance, we could presume there is assault because we could reasonably anticipate harm with the bat coming at Freddie, but no, Freddie was never even hit with the bat. It's also important to note, in the world of assault, especially in game and or sport contact situations, the element that is difficult to prove in a sport context is this notion of intent to bring harm. Oftentimes in sports settings, it would be difficult to prove that. Okay, that gets us through our first intentional tort, assault. Assault, we'll see, leads us to our second intentional tort, and that will be battery. Once we've gotten through assault and battery, we'll then address the potential defenses to these intentional torts. Let's move on to our second intentional tort, battery. This falls along a similar vein as assault, but there's going to be one key distinction. As with assault, battery also has 3 elements that must be present to constitute a civil battery. You'll recognize that the first one is similar. There has to be an intent to touch or cause an offensive act. The key distinction between assault and battery comes on the second component, where the intent is. This is the indication there has to be actual touching. A harmful or offensive act must have been committed. And lastly, there is that notion of causation, or as we talked previously under assault, lack of consent. So hopefully we recognize within the three components here, they're very similar across assault and battery. However, with assault, there does not have to necessarily be actual physical touching. And with battery, there is. Let me provide you an example of what battery might look like. Let's say, for example, that Smith was guarding Tommy, and Tommy was about to receive a pass during a basketball game. Smith intentionally pushed Tommy from behind and punched him in the back of the head. We could constitute this on battery only. I also want to point out there are many instances in the world of sport. Take, for example, boxing and or maybe football. There is physical contact that outside the domain of that sport would indeed be battery in a court of law. So what's the distinction then? That comes in the area of consent. Typically, sporting participants consent to the physical contact that occurs within the rules and bounds of the game. Notice that last language, within the rules and bounds of the game. What does that mean? When an individual steps into a boxing ring as a participant of that sport, they have consented to the rules and bounds of the game. And as we know, in the game of boxing, or in the sport of boxing, I should say, that means using your fists to punch your opponent, completely within the rules and bounds of the game. And that's that notion of consent or causation. Same within the world of football. If there's a football player that decides while walking across campus to tackle another student, by all means that could be battery because the other student has not consented to these rules. But as we know, when that football player is playing on the field, all participants who wouldn't step in the lines have consented. Therefore, that's where oftentimes in the world of sport, we need to recognize that battery is outside the realm when people are participating. However, I do want to caution us when individuals act outside the rules and bounds of the game, it indeed could be battery. Let's discuss our possible defenses for assault and battery. While not mentioned on the slide, hopefully we're starting to recognize if in the previous discussion we talked about assault and battery must require 3 elements to be included assault and or battery. If one of those 3 elements is not proven, that's potentially one of our defenses. Our other 2 additional defenses come under consent and privilege. We've already given some discussion to consent. We particularly see this in the world of sport. I do want to caution us though, that there can be questions given to how much or to what extent of consent is given. It's also important to note that consent can be expressed. It can be verbal or it can be written, but also can be implied. For example, when stepping on the field of play, it's implied that individuals consent to the rules. In the same way, if we stepped into the boxing ring, whether we verbally or expressed our consent in written form, it's implied that we're consenting to play by the rules of boxing. However, it's important to note that in many instances, if assault or battery is considered in the world of sport, we don't, as sport participants, typically consent to those behaviors that are outside the realm, norm, or rules. Okay, let's talk about privilege. This is our third potential defense to assault and battery. I think the second statement gives us the best description in kind of a simplified fashion. Privilege is commonly used in instances which the defendant has acted in defense of his or her property. It's the privilege of that defendant to defend, we could say, their property. That could be self-defense themselves. It could be the defense of someone else. It could be defense of some type of property, and it also could mean the defense of our own personal property. One caveat as we talk about privilege. It's never a privilege to use force when immediate danger has passed or is no longer present. What does that mean? It is not acceptable and is not included privilege for a defendant to continue to act when an immediate danger has passed or is no longer present. Okay, so what are our defenses for assault and battery? There are 3 of them. Please recall it goes back to not being able to prove one of the 3 elements, consent, and privilege. We've arrived at our 3rd intentional tort. This is infliction of emotional distress. In order for an emotional distress claim to be made, there must be 4 elements. I've included those here. It's important to note then that a defense of emotional distress would be the inability to prove one of the 4 elements. Let's talk about these 4 elements. There has to be extreme and outrageous conduct by the defendant. In addition, the defendant did intend to cause the plaintiff emotional harm or recklessly disregarded that the plaintiff might be emotionally harmed. Note there, because we're talking about an intentional tort, there is intent. Third, the defendant's behavior was the cause of the emotional distress. And finally, the plaintiff had severe distress and damages. Please recall, if we go back to an intentional tort, there must be an intent to act and indeed an intent to harm. Both of those components are aligned within these 4 elements. So how does this apply to sport and the world of sport? Oftentimes we see this in potentially media, and that's an important area that we need to recognize. Sport organizations then have to be mindful that the statements they make about players, staff, personnel could indeed inflict emotional distress if those comments, particularly made to the media or in print, are in regard to playing time, ability, career aspirations, and even employment. So sport organizations in and of themselves must be mindful that they could potentially be liable if they behave in a way that inflicts emotional distress on a player, an employee, maybe a staff member. As I've already indicated, it's important to note then what would be a defense of emotional distress. It's the inability to address one of the 4 elements. That gives us our 3rd tort. Let's move on now and talk about our 4th intentional tort, defamation. This may be a more commonly heard of intentional tort. This is concerned with defamatory statements that impact the reputation of a plaintiff. In order to establish a claim of defamation, we have to have the following 4 elements in order to be present. There has to be a false statement. It has to have been published to a third party. There has to be fault of the defendant, or at least some degree of fault on the defendant, and there has to be some type of damage or injury to reputation. In the next 2 slides, we are going to talk about 2 categories of defamation. One is libel, it's written word, it's published, it's internet, it's print, it's magazine. Or defamation could come in the form of slander, that's spoken word. We might see this potentially on talk shows or radio podcasts. An additional form of defamation is slander per se, or defamation per se. It could also be libel per se. This notion is that the false statements are so damaging, the victim doesn't have to show or prove that there were damages or injury to the reputation. Some of those might include the following. Such things as if the statements accuse the plaintiff of a crime involving moral turpitude. It also could be where the plaintiff is accused of having some type of loathsome disease. There could be an accusation of unchastity or sexual misconduct, or these accusations could arrive around the profession, business, or trade. So we have to think about it in a couple ways. And in the next two slides, we are going to look at libel and slander in more detail. It's also important to note that there may be a more extreme form of defamation, libel or slander, and that is defamation per se, libel per se, and slander per se. And in that instance, the plaintiff, does not have to prove those special damages. And it has to fall under classification of one of kind of those four accusations. Okay, let's move on now and talk about libel and slander. Let's move on and talk about our first form of defamation, libel. Please recall, as we already said, libel is a written word. It could be published, and particularly in today's modern age, we could talk about published on the internet, social media, magazine, and newspaper. There are three classes of libel. We've already talked about that first one, libel per se. That is the notion that those statements are so damaging that the victim does not necessarily have to prove financial damages. Please recall our previous slide on that list of what that libel per se might look like. Our second class of libel would be materials that could be considered defamatory. And our third class is materials that are not themselves defamatory, but when combined with other facts, they become libelous. There's four elements of libel, just like we've seen in defamation. There has to be the defamatory statement, the publication of the statement, there has to be fault given, and there has to be damages. So one of the possible defenses against libel would be that one of those four elements is not proven. In addition, there also could be what we call a qualified defense for libel, and that's truth. So for example, the person publishing these statements must prove that the statement that is made is true. And if that is the case, then libel could be defended. Also, it's important to note that if the statement is false, the plaintiff must prove that the defendant published the statement with ill or hatred and with no regard for the public's need to know. We see this at times in some of our more shock value media outlets. I was thinking, for example, something like a TMZ magazine. They have repeatedly been under the case of being sued for defamation, particularly libel. It is important to know, though, that in our example, TMZ could have a qualified defense, and that might be true, that they indeed are publishing the truth. Or that they published this with no ill will intent. Okay, let's take a step back. So defamation is technically our fourth intentional tort. There are two types of defamation, libel and slander. We've begun to address here libel. It's that written word. Please note there's three classes, and we also, just like we've been working through, there are three elements one must prove in order to determine libel. But just like previously we've known, we also have some defenses for libel. Big one, truth, and we've talked about that here. We're going to move on now and talk about slander. Our second form of defamation is slander. Please recall libel is written word, slander is spoken word. There are four elements that have to be proven for slander to be taken place. There have to be defamatory spoken words, and those spoken words must be a publication or published to a third party. What does that mean? They must have been spoken to someone else. That can be done in radio, broadcast, or simply someone else. The third element is the plaintiff must prove the statement was heard and understood by that third party, or holds the subject up to public ridicule or scorn because of the statement. And the fourth is that there must be financial damages. So what are our defenses for slander? As we hopefully recognize, this is similar across libel. Truth. Truth is an absolute defense. The plaintiff must show, though, that the statement was heard and understood by that third party as truth. Also, it's important to know that the injury to reputation is not presumed. Therefore, the plaintiff must prove that their reputation was indeed damages, or that fourth element. I have one more thought we need to discuss with defamation before we move on to our final intentional tort. Defamation of a public person. It's important to keep in mind the courts have tried to balance this freedom of the press and an individual's reputation. Public figures and or many sports figures have acquired sufficient public attention to be more likely the target of comment and discussion than any of us. So therefore, an extra element must be proven when we're considering defamation of a public person. And that came out of our lawsuit of Gertz versus US. Is where that extra element must be proven. And in this instance, we must prove when we're considering a defamation of a public person that the defendant acted with malice or reckless disregard for the truth. Ultimately, this becomes very difficult for a public person to prove against a broadcast or news outlet. I want to reiterate, why is this the case? Our courts have repeatedly tried to balance this public freedom or freedom of the press, our public's right to know, with an individual's reputation. Okay, that's going to conclude our discussion on defamation. Our fifth and final intentional tort is invasion of privacy. This falls in line with our previous discussion about public persons. The purpose or thought behind invasion of privacy is that this is designed to protect against unreasonable interferences with a person's right to be left alone. In order for invasion of privacy to be proven, there are 4 elements or determinations. There are ways that one can invade the privacy of another. Particularly in our social media age, I think we see this are common elements. First, there has to be intrusion by the defendant upon a plaintiff's affair or solitude. There has to be publicly disclosing of these private facts, and there has to be a publication by the defendant that puts the plaintiff in the false light in the public eye. And the fourth, there has to be appropriation by defendant of a plaintiff's name or pictures, and those are used for the financial gain of the defendant. Our third and fourth elements, we could argue, are much easier to prove in this instance than the first 2 elements. We could see that element 3 and 4 could indeed be fairly easy to prove. It's where our first 2 elements come into play that make it difficult to prove, and therefore we could see where our defense for invasion of privacy is that one of our 4 elements is not proven. Okay, this brings us to our end discussion of intentional torts. We have addressed reckless misconduct as well as our 5 intentional torts: assault, battery, defamation, invasion of privacy, and infliction of emotional distress. It's important to note that several of our case briefs will help us see how these laws or torts are played out in our legal system. Remember, under each of these instances, there are elements that one must prove in order to determine that these torts did occur, as well as additional possible defenses.